So I'm going to be talking about environmental liability risk. When I first got tasked with coming down to talk about this, I started speaking to some of my colleagues in our environmental practice group, many of whom have decades of CERCLA experience. And I said, I'm going to be talking about opportunities for innovation in CERCLA. And I was commonly met with blank stares because there are a few statutes less amenable to innovation than CERCLA. Just a very quick background, it was thrown together at the end of the Carter administration. The Democrats had the House and the Senate. Jimmy Carter was president. The House and the Senate were working on different bills after some really horrendous environmental issues had come out in the 70s. And then in early November, Ronald Reagan was elected, and they basically took what they had and threw it together in a pretty haphazard way and got it passed and signed before Carter left office. And so some of the things that judges say about CERCLA are pretty remarkable in terms of just how poorly crafted it was, because it was a real hodgepodge thrown together. One of the more memorable quotes goes more to the liability than the structure of it is, CERCLA is like a black hole that consumes all who dare to come near. So my talk, unfortunately, doesn't have any pictures, and I'm talking about scary stuff. So this portion of the program will be a little like eating your spinach. Just need to figure out the technology. There we go. Okay, and so I'm going to be talking about the risks to both property owners and consultants, something you don't hear a lot about. But when I was talking to Paul, he mentioned, talk about consultant risk. And I thought, yeah, that's just something to consider. And so most legal risks for property owners and consultants at historic mine sites come from federal environmental statutes, primarily CERCLA, Clean Water Act. RCRA can come into play, but because of the bevel exclusion at historic mine sites, you really don't see RCRA as a big player here. And so with respect to risks to property owners, those are primarily CERCLA, Clean Water Act, and third-party tort claims. Risks to consultants are primarily CERCLA, breach of contract, and third-party tort claims. They don't really have Clean Water Act risk unless they spill something because they don't own the discharge point. And so I'm really going to focus on CERCLA. I'm going to talk a little bit about Clean Water Act, but CERCLA is really the big player here. So the Clean Water Act regulates discharges of pollutants from point sources to navigable waters. Navigable waters are defined as waters of the United States. You say, what does that mean? That's a very good question. That's under significant litigation now, as it has been. You may have heard about the Waters of the U.S. rule that's being litigated right now. Well, as of week before last, you have one definition of waters of the U.S. in 26 states and a different definition in 24 states. And so we're not going to drill into that. But unpermitted discharges can have significant penalties, civil criminal enforcement actions, and substantial fines. And Section 402 is the point source discharge provision of the Clean Water Act. Some of you may be familiar with 404, which is the dredge and fill permit that you need to get before excavating or discharging sand, rock, gravel into water bodies. Most states have been delegated authority to enforce Clean Water Act 402. So for example, in Colorado, you get your CPDES permit from CDPHE's Water Quality Division, not from EPA. And I think something like 46 states now have delegated authority. And so a point source is a discrete conveyance, such as a pipe, man-made ditch, that discharges pollutants into the waters of the U.S. A draining adit typically is considered a point source discharge. A case came out a couple of years ago where you had a waste pile with diffuse discharge around the perimeter of the waste pile. That was not a point source. And site-specific NPDES permits have numerical effluent limits for specific pollutants and then monitoring requirements. And this is what Linda was asking Betsy about in terms of these rigid numerical standards, because these rigid numerical standards are really problematic in historic mining areas because they typically have high background concentrations of particularly metals, especially where you have a lot of sulfides. And so what can happen, and one issue that's going to have to be resolved, especially with respect to Bonita Peak, is once you remove or mitigate the anthropogenic contribution of metals to a water body, what about the background levels? Very often, you're going to still exceed numerical Clean Water Act limits even after conducting a response action simply because of background contamination from natural sources. And so that's going to be a pretty big source of discussion. Not here, but here. Okay, now we'll talk about CERCLA. CERCLA is probably one of the most scary laws that was ever passed. The liability scheme is retroactive, strict, joint, and several. Retroactive means, yes, if it was disposed in 1898, somebody today can still be on the hook for it. Strict means that you don't have to be negligent. The second bullet, liability is based on status, not conduct. We'll talk about that in the next slide. And then the release of hazardous substances key. And hazardous substances is a defined term. It covers lots and lots of different materials. The old saying is, if you drop a penny into a Superfund site, you're potentially jointly and severally liable to clean up the entire thing because copper is a hazardous substance. And so CERCLA allows both private parties and the government to recover response costs for cleaning up hazardous substances. You don't need an NPL listing to be able to invoke CERCLA. If you clean up a site and you recover response costs and there's another party involved, you can bring a CERCLA contribution and sometimes cost recovery action against them, even if there's no NPL listing. And so that's one thing when you say Superfund site, that's not the be all and end all of Superfund. There are a lot of private party actions. In fact, boy, most of what I've done were private party actions where EPA names a few big players and then all the other players fight amongst themselves on who pays how much of the total cost. So as Anthony mentioned briefly, there are 4 categories of responsible parties. And this goes back to what I was talking about, status liability, not negligence or conduct liability. And so the current owner or operator of a facility at which hazardous substances have been disposed is liable, as well as a past owner or operator at the time hazardous substances were disposed, arrangers for the disposal of hazardous substances, and transporters of hazardous substances. So if you fall into any of these categories, it doesn't matter how careful you were, whether you followed industry practices, whatever. If you fall into these categories, then potentially you're liable under CERCLA. Okay. Am I pointing this backwards? Okay, so current owners are jointly and severally liable even for historic releases. So current owners, you're on the hook for whatever happened historically. Liabilities is imposed regardless of whether historic operations were legal or consistent with industry practices at the time. Again, it's strict liability. There are defenses to CERCLA liability if you're thinking of acquiring a property. I do a lot of due diligence on mine acquisitions and so on, and when somebody says, I'm thinking of buying a property, the first question I ask, is there a water discharge? Okay, that's sort of the key question I ask, because that's one that is I think somebody mentioned yesterday, the gift that keeps on giving. The defenses for CERCLA that were added in 1986 are the innocent landowner defense, the contiguous property owner defense, and the bona fide prospective purchaser defense. And these are available if you conduct what's known as all appropriate inquiries, which is a term in the CERCLA statute. And that basically means following the ASTM standard for phase 1, phase 2 site assessments, or following the AAI regulations, the process there, which pretty much follows the ASTM process. If you conduct appropriate inquiries, you might be able to invoke some of these defenses if you acquire a property with historic liabilities on it. The trick with innocent landowner and contiguous property owner is they work only if your investigation doesn't find anything. The bona fide prospective purchaser defense is the only defense that you can use if you do an investigation and you find out, oh yeah, there's been a release of hazardous substances. However, one of the elements of invoking the BFPP defense, there's several steps you have to take, cooperate with EPA, don't mess with institutional controls, that kind of thing. But one is taking reasonable steps concerning hazardous substances releases, including stopping continuing releases. This again takes us back. This could mean meeting surface water quality standards for metals if a mine is discharging. And so the BFPP defense may not be that helpful in most cases where you are acquiring a mine site and you have an elevated contaminant discharge issue. With respect to contractors and consultants, the biggest risk they run into is becoming what's known as a CERCLA operator. And this is the definition of CERCLA operator. The Supreme Court came out with in 1998 in a case that we actually filed a brief in, United States v. Bestfoods. The primary focus of this case was parent corporation liability for operation at a subsidiary's facility. But what the Supreme Court did is they put a finer point on what it means to be an operator. And what they said is an operator must manage, direct, or conduct operations specifically related to pollution. That is, operations having to do with leakage or disposal of hazardous waste or decisions about compliance with environmental regulations. So being the RCRA geek that I am, the first thing I noticed is, why are they using the term hazardous waste, which is a RCRA term, in a CERCLA decision? It deals with hazardous substances, but the Supreme Court can't be an expert in everything. So the thing to focus on here is there are basically two elements. The first is managing, directing, and conducting operations relating to the leakage or disposal of hazardous substances. Every consultant in the room is thinking, isn't that what we do every day? The second one is decisions about compliance with environmental regulations. But there is a provision in CERCLA to provide some protection to response action contractors, section 9619. It states that contractors responding to releases are not liable for damages caused by the release unless the contractor is negligent, grossly negligent, or engages in intentional misconduct. So what this does is it brings a negligence standard back into a strict liability statute and applies it to contractors. Well, it's not a get out of jail free card. It's interesting because getting ready for this talk, I've looked at this issue over the years, was aware of contractors becoming liable under CERCLA for moving contaminated soil around a site, that kind of thing. But I went back and checked the sort of more current case law on this, and it is a real mess. There are cases out there where people have brought CERCLA actions against contractors, and this provision is never cited. I don't know if they didn't raise it as a defense. There are cases where courts are using an authority to control test, which the Bestfoods case said no longer applies. The upside is there's no huge trend in bringing CERCLA cases against contractors. Okay, so there aren't a lot of cases out there, but something you should be aware of, especially if you're a big consulting firm and you're doing sort of a flat fee, will take care of everything at the site. There's some risk that you are then making decisions about compliance with environmental regulations and including making decisions about disposal of hazardous substances. So if you're just moving dirt on a site, you probably aren't falling into that category unless you're moving contaminated soil without characterizing it. So the other scenarios where contractors have been hit with CERCLA liability are failing to properly characterize waste before disposing of it, or drilling through an aquitard and cross-contaminating aquifers. So it's just something to keep in the back of your mind. Like I say, it's not something to lose sleep over if you're a consultant, but be aware it's out there. Now, NCP compliance. This is really one of the most important pieces in terms of implementing innovative technologies at Superfund sites. Because the NCP, as many of you know, especially those who are in the midst of doing an RIFS, is really the cookbook for how to do a CERCLA cleanup. And so to recover response costs, keep in mind, CERCLA doesn't provide damages for bodily injury, property damage, anything like that. It's only about response costs, okay? So to recover response costs, they must be incurred in compliance with the National Oil and Hazardous Substances Pollution Contingency Plan, also known as the NCP. This is one of the elements of bringing a CERCLA claim. It's NCP compliance. And it's the primary guide for doing CERCLA cleanups. And so, as many of you know, the NCP breaks down environmental response actions into two broad categories: removal actions that are generally, remedial actions that are generally considered long-term permanent remedies. That's where the RIFS has conducted a very detailed analysis of all of the data at this site, remedial alternatives analysis and the like. Removal actions are typically taken in response to an immediate threat and primarily are intended for short-term abatement of hazards. That's where you see the ECA, the engineering evaluation and cost analysis. It's a very streamlined RIFS. You still have remedial technology comparisons and so on. The line between these is very fuzzy. There's a lot of litigation about whether something's a remedial action or removal action, because if it's a remedial action, you have a lot more work to do than if it's a removal action in terms of teeing up your remedy. So the two key NCP elements that I want to focus on are those that I think are most heavily litigated. I've litigated these issues, and they're really sort of the core of being able to recover response costs by complying with the NCP. One is meaningful evaluation of remedial alternatives, and the other is opportunity for public input. If you're at an NPL site, EPA is going to handle the public relations piece, so that you generally don't have to worry about that. But without a meaningful evaluation of remedial alternatives, you don't get response costs. There have been many cases where people just went through the motions. They had a presumptive remedy going in. You can tell all the way through they were just sort of affirming their thinking process going in. And courts say no. When we say meaningful remedial alternatives analysis, we mean it. And so even states have been denied cost recovery, where they went in with, there was one case they had a novel soil washing technology, and they just went ahead and implemented it and went to court and tried to recover their response costs under CERCLA. And the court said, no, you did no meaningful alternatives analysis. And so, that's baked into the ECA and the RIFS process, but those are critical. So anytime you're implementing a new technology, you want to make sure you stay within the framework of the NCP. There are a couple other opportunities I'll talk about that are a little more streamlined than that. So I'm briefly going to talk about the EPA's Good Samaritan Initiative because Paul asked me to. There are people in this room who are much closer to this issue and know a lot more about it than I do. I don't deal with it a lot because my clients can't use it, as you'll see. And so I'll just run through the basic elements. If we have a discussion about Good Samaritan, I'd like to rely on my very large bullpen here to jump in as well. So the initiative, as it stands now, encourages volunteers to clean up orphaned mine sites without incurring liability under CERCLA or the Clean Water Act. When they first came out with this, it applied only to CERCLA, and a few years later they said, well, we kind of really need to add this Clean Water Act because it doesn't really do much good if we don't include both. So you're limited in terms of being able to extract mineral reserves. It doesn't apply at NPL sites. It doesn't apply if somebody's a PRP. And if you get there and you're basically an NGO who goes in and voluntarily cleans up a site, you can get less stringent cleanup standards than surface water quality standards. And that's sort of the end goal. And again, that's the piece that keeps coming back around, is what happens at the end of the day when you still have discharges that exceed surface water quality standards. So what are the options going forward given sort of the limits of this really scary liability framework? One thing clients are always surprised to hear, and this has happened several times, is they say, what should we do? We say, we think you should proceed under CERCLA. And they look at us and say, are you nuts. And there are some upsides to proceeding under CERCLA. For one, there's the CERCLA 121E permit waiver. No federal, state, or local permit shall be required for the portion of any removal or remedial action conducted entirely on site. This applies to RCRA permits, Clean Water Act permits, both NPDES and 404 discharge permits. So that is a huge upside. There also is a provision called 113H that prohibits anyone from bringing a suit that could be construed as interfering with the cleanup. So it gives you protection against anyone challenging the remedial decision. And so another option to consider is settling with EPA or a state, because that triggers all kinds of protections. You can enter into an administrative settlement agreement and order on consent, ASAOC, a judicial consent decree where they simultaneously file a complaint and a settlement at the same time. The settling party gets contribution protection against cost recovery or against contribution claims from other PRPs, and a covenant not to sue from the government if you comply with the terms of the settlement. And the work is deemed NCP compliant. So those are some real big upsides if you find that you're already in the CERCLA box, because again, it's status liability. If you're in one of those categories of liable parties, you want to find a way to move forward and get protection from these risks. You also can negotiate a unilateral administrative order. I've seen situations where you're negotiating an ASAOC and the parties just can't agree, and so they'll agree to have EPA issue a unilateral administrative order. An ASAOC, commonly you have to provide financial assurance to back up the remedy. That's not true with a UAO, and the agency can't order you to pay response costs, the agency's response costs. In an AOC, those are usually negotiated. It can be the same work plan you were working on in your negotiation with the ASAOC, and you still get the CERCLA 121 permit waiver, but you don't get contribution protection or a covenant not to sue by the government if you're in the UAO world, but it is an alternative. And this is something that Betsy mentioned, and this applies where you do have an RIFS ongoing, and that is an interim removal action or pilot test. Interim removal actions typically started off where you're doing an RIFS on a property and you go out and you find, oh, somebody buried a bunch of barrels. We need to move on it, and we'll do an interim removal action. The upside is you can do it without having to do an ECA, much less rigorous NCP requirements. If cleanup goals are met on an interim removal action, the liability risk is greatly reduced, especially if you end up meeting surface water quality standards. Then your interim removal action couldn't end up being a permanent removal action. So this is where folks can go in and deal with very simple kinds of issues at sites to move waste rock out of the stream, or deal with added openings, that kind of thing. And so this is an opportunity to really do something without all the bells and whistles that CERCLA usually requires. So what if water quality standards are still exceeded after a CERCLA removal action? Your options are limited, right? Because right now we have the CERCLA 121E permit waiver, which means you don't need a Clean Water Act permit. Well, what happens when that CERCLA umbrella is lifted and you still are exceeding surface water quality standards? Are you going to have to get an NPDES discharge permit? One alternative is to bake in some ongoing O&M obligations in your work plan such that you just extend the life of your 121E permit waiver. But a lot of this is going to depend on the state's position, because they're the ones who have delegated authority under Clean Water Act 402 in terms of what their requirements are going to be. So this is really asking more questions than providing answers at this point, because this is going to be one of the big questions that we're going to be dealing with. Again, that gets back to the issue is, at these kinds of sites, especially we have such high background concentrations, are people really going to have to meet surface water quality standards? And one thing about CERCLA in the statute, it precludes using CERCLA authority to clean up any naturally occurring minerals. So you can't use CERCLA to go below what historic metals levels were pre-mining. So that's it, and we'll see you back for the panel. Thanks.